resource. I have a few instructions from our Honorable PDJ Garu to be conveyed to all the officers. His Lordship has asked all the judicial officers to number the charge sheets, because it appears that there are so many charge sheets which are to be numbered, neither they are being written nor they are being numbered. So His Lordship has asked all the officers, wherever charge sheets are pending in their respective courts, including the special courts, those charge sheets have to be immediately numbered, and if there are any objections, they have to be returned by raising those objections. And as far as the case property is concerned, if that property is to be produced, you can seek an undertaking from the investigating officer that the said case property shall be kept with the investigating officer in safe custody as an interim measure, and till regular work is taken up, the property would be deposited as and when the courts would be reopened for conducting regular work. So with that undertaking, you can permit the investigating officer, and on that basis you can number the charge sheets. And secondly, where written statements are filed in suits, His Lordship has asked all the officers to go through the written statement and prepare the draft issues, and they should be made ready so that immediately as and when the courts are opened for taking up the regular work, issues can be framed and trial can be proceeded with. And thirdly, His Lordship has asked all the officers that wherever the matters are ripe for disposal, to dispose them off immediately, and when the matters are posted for arguments where the advocates are not coming forward to argue the matters, His Lordship asked the officers to go through the file and prepare the draft judgment, at least to considerable extent, so that if arguments are advanced, on that basis you can mold the relief. So in this manner you can better utilize the leisure time now we are having, because this time would not come up again and again. And His Lordship asked all the officers to show progress in disposal of the cases, and expressed concern that the disposal rate in the month of August is very slow when compared to the disposal rate in the month of July. Honorable PDJ Madam also wanted to convey these instructions of His Lordship to all the officers, and I request each one of you to take note of these instructions and proceed accordingly. Okay. Now I request our resource person kindly to take over the proceedings and commence his webinar on the topic. Thank you.
Thank you, sir. And good evening to the Honorable District Judges, Senior Civil Judges, and the Magistrates of the Karimnagar Unit. At the outset, I would like to thank Honorable Portfolio Judge of Karimnagar District, Honorable Principal and District Sessions Judge, and also Honorable First ADJ for innovatively creating this platform of learning called webinars.
Sir Sharma, please one second. I forgot to mention, today's legal word would be given by Sri Pradeep Garu, JCJ of Karimnagar headquarters, and vote of thanks would be proposed by Sri Parvatrup Ravi, JCJ. Please, these two officers are requested to make a note of it and get themselves prepared. Okay, sir. Yes, you can commence, sir. Please proceed.
Thank you, sir. Once again, a very warm good evening to all the Honorable District Judges, Senior Civil Judges, and the Magistrates of this unit. And at the outset, I want to thank Honorable Portfolio Judge of Karimnagar District and Honorable Principal District and Sessions Judge and Honorable First ADJ Garu for innovatively creating this platform of learning called webinars for the benefit of all the officers in these times. And I also want to extend my sincere thanks to the staff behind the scenes who have been relentlessly keeping pace with the requirements for the smooth functioning of these webinars. Now coming to the topic I chose to present in today's webinar is former statements, how to record contradictions with respect to those former statements in writing made to the police and its evidentiary value. Statement generally mean an opinion or message conveyed, and former or previous statement mean any statement made previously by the same person. The terms statement and former or previous statement are not defined either in the Code of Criminal Procedure or in the Indian Evidence Act. But a former statement in legal parlance can mean a declaration of fact or an allegation made previously by a witness. And the former statements are used to contradict the witness in both civil and criminal proceedings. But in the present topic, the use of former statements in criminal cases are alone dealt with.
Sharma, please, your video is not visible. You have switched off your video. Please open up your video.
Sir, the video is switched on, sir, but only thing is I am reading it only directly from the system, sir. I am just alt tabbing the
But your video, your face is not visible. You should be visible to all the participants. You are not supposed to switch off your video.
No, it's not switched off, sir.
But I am unable to see you. I am getting a mark that your video is closed. And let us ascertain from other officers whether he is visible to all of you.
No, sir.
No. Sir. No. No, nobody is able to see the resource person.
Sir, sir, in that case, I may be permitted to log in from my mobile phone, sir.
See, this arrangement you should have made earlier. How can you switch off your video and go on reading?
No, sir, I have not switched off, but
No, you should have taken out a printout of your paper and you should have read it out by keeping your video mode on. Highlight you switch on your cell phone and start reading from your video, but your face should be visible to all of you, is it not? The purpose of this webinar is to see that we will be able to see the resource person while interacting with all the participants.
Sir.
Okay, do it immediately.
Sir, 1 second, sir.
Because the video recording of this webinar, which is uploaded in the YouTube, will be sent to the Honorable High Court and the Honorable Portfolio Judge. His Lordship would be viewing it. And without knowing who is the resource person, how does His Lordship know? So all are requested not to switch off their videos and keep their videos on. And the resource person is expected to be on the video always till the conclusion of the program.
Until sir, is my video on, sir? No, can you?
Sir, కనిపిస్తుంది.
Yes.
Yes. Now you can proceed, sir.
Thank you, sir. Statement generally mean an opinion or message conveyed, and former or previous statement mean any statement made previously by the same person. The terms statement and former or previous statement are not defined either in the Code of Criminal Procedure or in the Indian Evidence Act, but a former statement in legal parlance can mean a declaration of fact or an allegation made previously by a witness. And the former statements are used to contradict the witness in both civil and criminal proceedings. But in the present topic, the use of former statements in criminal cases is alone dealt with. The former statements pertaining to the evidence of a witness can be oral or be reduced into writing. But for the purpose of using those former statements as substantive evidence, the same has to be reduced into writing or should be in electronic form. The term statements occurring in section 161 of CRPC mean the ones which the police as part of their investigation record, and their use is governed by section 162 CRPC. Whereas the term previous statements occurring in section 145 of Indian Evidence Act are not limited only to the statements recorded by the police, but also includes other previous statements made by the person who deposes as witness in a trial. The relevant provisions are extracted hereunder further. Now I'm leaving out these provisions as is. What statements can be called former statements in writing? As stated above, section 145 of Indian Evidence Act does not only include the statements under section 161 CRPC, and hence the party can make use of any other former statements that the witness has previously made and was reduced into writing in order to contradict the witness. And what all can be called as former statements of the witness is settled by Honorable Apex Court through various case laws, and some of which are dealt below. In State NCT of Delhi versus Mukesh, while the Nirbhaya case was on trial, the counsel for the accused wanted to confront and pose questions on a TV interview given by the PW1, contending that the same can be treated as former statement. This contention was rejected by trial court, and in the revision, the Honorable High Court of Delhi set aside the order of trial court and allowed the petition, holding that the TV interview given by PW1 is a former statement. This was challenged by the state, and when the matter reached the Honorable Supreme Court, the three-judge bench set aside the order of the High Court, and while restoring the order of the trial court, observed that the word previous statements used in section 140 of Indian Evidence Act does not include the statements made after filing of the charge sheet, and opined that the statements made by the witness before police during the investigation are alone qualified to be used as former statements for the purpose of contradiction. From this judgment, the scope and ambit of what can be called former statement was narrowed. However, in Jasdeep Kaur Chadda versus State NCT of Delhi, the prosecution in this case wanted to confront a previous statement to the witness, which the witness made after filing of the charge sheet. The trial court, relying on the judgment in Nirbhaya trial case above, did not allow the public prosecutor to confront the same. The matter was then carried to Honorable High Court of Delhi, which confirmed the order of the trial court, and the Honorable High Court of Delhi also relied on the same Nirbhaya trial case. And then the matter was carried to the Honorable Supreme Court, where two judges of Honorable Apex Court, taking note of the decision of 4 judges bench in Tara Singh versus State and of 3 judges bench in Mohanlal Gangaram Gehani versus State of Maharashtra, both of which were pronounced prior to the judgment in Nirbhaya trial case above, on the same aspect, held that section 145 of Indian Evidence Act has not put any limitation that the previous statement must be during investigation, and further opined that if the statement is in writing and is relevant to the matter in question, the same can be used as former statement. Further, it also observed that the court in State NCT of Delhi versus Mukesh has not taken note of the view taken by the larger bench in Tara Singh, and hence held the judgment as per incurium. Now, it has been made clear by the Honorable Apex Court that the statements, irrespective of them being made during the investigation or after, can be considered as former statements. The said former statements can be confronted if the same are reduced into writing or recorded through electronic media. And further, the statements need not be the only ones made to the police. FIR, a former statement. In Dharmaram Bhagare versus State of Maharashtra, 3 judges of Honorable Supreme Court held that the FIR is a former statement and can be used for corroborating or contradicting its maker. But it cannot be used as substantive piece of evidence because it is not made to the police, and also it is made to the police, and also the ingredients of oath and cross-examination are absent. Police diary as a former statement. Section 172 CRPC, the accused cannot, as a right, use the contents of police diary as former statements for the purpose of contradiction or corroboration. There are 3 clauses under Section 172 of CRPC, which states the need to maintain and the mode how to use the case diary. The first clause directs the investigating officer to enter the day-to-day entry of the status of investigation, including the persons interrogated and places visited, along with the date and time. Any criminal court can call for the case diary maintained by investigating officer for which the case is under trial, and the contents of the case diary can be used to aid in inquiry or trial but the said contents cannot be used as evidence. The accused does not have the right to call for the case diary or entitled to refer the contents, even if the same is referred by the court under section 172 clause 2 of CRPC. But the third clause provides for two exceptions as to when the accused can use the contents of a case diary. Firstly, if the court uses the contents of case diary to contradict the investigating officer, and secondly, when the investigating officer himself refers to the case diary for the purpose of refreshing his memory. In both these circumstances, the provisions of section 161 CRPC and section 145 of Indian Evidence Act can be invoked by the accused. In Mahabir Singh versus State of Haryana, two judges of Honorable Apex Court, while explaining the power of court under section 172 clause 3 and how and when the said power can be invoked, opined that the court is forbidden from using as evidence the entries of case diary which it refers. But when the court uses those entries for contradicting the police officer, the same has to be made available to the accused to use the same as former statements. Further, the court should not, in exercise of the same power, aid the accused in explaining the contradiction which the defense has raised. Police diary of former or counter case can be used as former statement in the case under trial. In State of Kerala versus Babu, the accused initially moved an application before the trial court seeking to summon a case diary of a previous counter case which contained the 161 CRPC statement of a witness who deposed in the present case. The trial court allowed the petition. The state carried the issue to Honorable High Court, wherein the Honorable High Court of Kerala upheld the order of the trial court. The matter was then carried to Honorable Supreme Court, and the Honorable Court, answering the issue, observed that Section 172 CRPC has not taken away the right of the accused to use the statement of a counter case as previous statement for impeaching the credit of the witness, and the case diary of a different case can be summoned and used as former statement by the accused by taking recourse to Section 91 of CRPC, which now makes it clear that the case diary of a different case can also be used as former statements. Now, statements withheld or not supplied to accused and remedy available to the accused. As a general rule, the accused must be supplied with the statements recorded under section 161(3) of CRPC. Withholding the same would vitiate the canons of fair trial, and accused will not be in a position to use the statements for any purpose. But the police investigating officer under section 173 clause 6 may request the court to not furnish a particular statement or part of a particular statement to the accused by duly mentioning the reasons why such request is being made. The court then has the power not to supply those statements to the accused while complying with section 207 of CRPC. The statements which the police can seek to withhold are mentioned under section 173 clause 5 subclause B of CRPC, and the two judgments of Honorable Delhi High Court that can be gainfully referred to on this aspect are Dharambir versus CBI and Ujjal Das Gupta versus State. In Zubair et Subu and others versus Union of India, represented by National Investigating Agency, the Division Bench of Honorable High Court, speaking on the right of police in seeking to exclude a statement or part of statement to be given to accused, and the power and obligation of the court in not supplying such statement to the accused, held that section 173 clause 6 CRPC gives a power to the investigating officer to exclude the part of the statement from the copies to be supplied to the accused. Further, it was opined that the court is under obligation to withhold those statements, as nowhere in section 173 CRPC the court's power to reject the request of the investigating officer is mentioned, which makes the right under section 173 clause 6 a valuable right of the police officer. It was also observed in the same case that the accused at the stage of trial may suffer prejudice on account of exclusion of such statements, and the court, to ensure a fair trial, can order supplying of such excluded statements at the appropriate time of trial. However, that will not confer a right on the accused to claim such statements beforehand. Now, contradiction with regard to former statements recorded by police. The identification of witness as to who can depose before the court in a criminal case initiated on police report is a matter in the hands of investigating officer. The police, as part of their investigation, has got the powers to examine those persons whom they think have first-hand information or knowledge of the crime, and they are at liberty to record the statements of such persons in writing or otherwise. The contradictions and omissions and the mode of proof that would be dealt hereinafter is when such statements were reduced in writing by the investigating officer, which would become former statement of that witness who may depose before the court at the time of trial. Omissions and contradictions both relate to such former statements made by the witness, but the same were not defined either in the Evidence Act or the Code of Criminal Procedure. But the cause of such omission or contradiction and their effect on the evidence of the witness has to be dealt by scrutinizing the depositions of the witness, including the mode, how the contradictions or omissions were brought on record, in order to come to a just conclusion of the case at hand. The dictionary meaning of contradiction is to offer the contrary. That is, when a person examined by the police under section 161 CRPC has stated a certain fact in a certain way, and he deposes such fact before the court in a different way, it is a case of conflict between the deposition in court and the statement made to the police, and is termed as a contradiction. Therefore, statement before the police can be used to contradict the witness. For example, an eyewitness to a murder in the trial before the court deposes that he saw X and Y stabbing A, while Z held A forcefully. Whereas in the statement given to the police, he states that X held A and Y and Z stabbed A. Now, this is a contradiction. What are omissions and what omissions or contradictions? An omission means to exclude or leave out something. When a particular fact is not stated before the police by the witness and he states the same for the first time in the court at the time of trial, it is an omission. In the example mentioned above, if the witness in his statement to the police has omitted to state the overt act of X and has only stated about Y and Z stabbing A, and in the court states that X held A while Y and Z stabbed A, the mentioning of the overt act of X in the court, which is missing in 161 CRPC statement, is an omission. What omissions are contradictions and whether such omissions can be raised by the adverse party in cross-examination. The 6 judges bench of Honorable Supreme Court in Tehsildar Singh vs. State of UP opined that relevant and material omissions amount to vital contradictions, which can be established by cross-examination and confronting the witness with his previous statement. The meaning given to the words contradict and contradiction must at least include the case of an omission in a previous statement, which by implication amounts to contradiction, and therefore such an omission is a matter which is covered by the first proviso to section 162, and questions in cross-examination can be put with respect to it in order to contradict the witness. Hence, all omissions on the face of it cannot be treated as contradictions, and an omission to become a contradiction, the fact has to be on the material point affecting the outcome of the criminal trial. Further, these omissions can be used by the adverse party to elicit any contradiction from the previous statement. Another question that arises is, if in a statement reduced into writing, the specific words or lines are not recorded, then whether the counsel can confront the statement for the purpose of recording a contradiction or put questions on the same in cross-examination. This point was also answered in Tehsildar Singh's case, wherein it was held that though a particular statement is not expressly recorded, a statement that can be deemed to be part of that expressly recorded can be used for contradiction, not because it is an omission strictly so-called, but because it is deemed to form part of the recorded statement. What can be deduced from the foregoing observation of the Honorable Supreme Court is that there are 3 kinds of contradictions that an adverse party can elicit from the witness. Firstly, which a witness states differently before the police and before the court. Secondly, which a witness has omitted to state before the police and states the same before the court. And thirdly, the witness, though not specifically states a fact, but the same can be deduced from the statements made before the police. Further, it is made clear that a statement not only includes what is expressly stated by person to the police, but also takes in its fold what can necessarily be implied therefrom. Even in the absence of a specific recital, some words or meaning crawls into the statement that the maker has not stated verbatim, and the questions can be put on such material aspects and contradictions can be elicited. Why omissions and contradictions are to be proved? The statement recorded by police under section 161 CRPC can be used for the limited purpose of contradicting the prosecution witness under section 145 of Indian Evidence Act, and may be used either by the defense counsel or by the prosecution with the permission of the court. Further, a statement not reduced to writing by police officer cannot be used for contradiction. The several modes of impeaching the credit of witnesses are enumerated in Section 155 of Indian Evidence Act. And Section 155 Clause 3 of Indian Evidence Act empowers the adverse party to impeach the credit of witness by proof of former statements with that of any part of evidence which is liable to be contradicted. And Section 145 of Indian Evidence Act enables the accused to cross-examine the witness on previous statements made by him. Mode of proving contradictions from former statements made to the police. The two limbs of Section 145 of Indian Evidence Act makes it clear that the former statements can be used in two ways. First, to generally contradict the witness without the contradiction being proved. This is done only to impeach the credit of the witness, and the former statement in this case need not be confronted to the witness. Second, if the intention is to prove those writings to make them as substantial evidence, then the specific parts of which the accused intends to prove has to be confronted to the witness. But drawing the attention of the witness itself does not make that part a substantial evidence. In such case, how the evidence and the contradictions elicited from the former statements made to police and the statement made before the court is to be brought on record. And when such contradiction is complete and proved is clearly explained by three judges of Honorable Supreme Court in V.K. Mishra and another versus State of Uttarakhand, wherein it was held that under Section 145 of the Evidence Act, when it is intended to contradict the witness by his previous statements reduced into writing, the attention of such witness must be called to those parts of it which are to be used for the purpose of contradicting him before the writing can be used. And while recording the deposition of witness, it becomes the duty of the trial court to ensure that the part of the police statement with which it is intended to contradict the witness is brought to the notice of the witness in his cross-examination. The attention of witness is drawn to that part, and this must reflect in his cross-examination by reproducing it. If the witness admits the part intended to contradict him, it stands proved and there is no need to further proof of contradiction, and it will be read while appreciating the evidence. If he denies having made that part of the statement, his attention must be drawn to the statement and must be mentioned in the deposition. By this process, the contradiction is merely brought on record, but it is yet to be proved. Thereafter, when investigating officer is examined in the court, his attention should be drawn to the passage marked for the purpose of contradiction. It will then be proved in the deposition of the investigating officer, who again, by referring to the police statement, will depose about the witness having made that statement. The process again involves referring to the police statement and culling out that part with which the maker of the statement was intended to be contradicted. And in case if the witness was not confronted with that part of the statement with which the defense wanted to contradict him, then the court cannot so motu make use of statements to police not proved in compliance with Section 145 of Indian Evidence Act, that is, by drawing attention to the parts intended for contradiction. Now, what can be deduced from the above judgment is that, firstly, the part of the statement in writing which the party wishes to contradict has to be confronted to the witness who made it and is to be recorded in the cross-examination. And if the witness admits to have stated that part of the statement to the police, then the contradiction so brought on record in cross-examination is complete and will be read while appreciating the evidence. But if the witness denies to have made the statement to the police which the party wishes to contradict, the same has to be marked and has to be recorded in the evidence of the witness. Finally, when the IO comes to depose, then the marked portion has to be confronted to the IO and record his answer, and then the contradiction is complete. Now, coming to evidentiary value. Now, Blackstone's ratio holds that it is better that 10 guilty persons escape than that one innocent suffer. It is equally settled that the societal interests at the same time should not be forgotten. According to Hindu Dharma Shastras, the purpose of any trial is the desire to find out the truth. Yajnavalkya, on how a decision has to be arrived at, stated that, discarding what is fraudulent, the king should give decision in accordance with true facts. This implies that the judge should leave out any embellishments, improvisations, and minor contradictions, and should pronounce the judgment based on the remaining facts by applying law. The contradictions properly brought on record by following the due process, as mentioned in V.K. Mishra's case, Supra, can be considered for evaluation while weighing and sifting the evidence in order to find the truth or otherwise of those contradictions. But how much reliance can be placed on such contradictions elicited is a matter of application of principles to the facts at hand, and no straitjacket observation can be made against or for the contradictions. In Rami alias Rameshwar was a state of MP, it was held that when an eyewitness is examined at length, it is possible for the witness to make some discrepancies, but only when such discrepancies are so incompatible with the credibility, the court can disregard the evidence of such witness, but not for mere variations falling in the narration on the incident of his own statements or from the statement of two different witnesses. Further, merely because there is inconsistency in the evidence of the witness from his former statements does not impeach the credit of the witness in entirety. In Bhoginbai Hijjibai versus State of Gujarat, it was held that the discrepancies which do not go to the root of the matter and shake the basic version of the witnesses cannot be annexed with undue importance. More so when the all-important probabilities factor echoes in favor of the version narrated by the witnesses. In C. Muniyappan versus State of Tamil Nadu, it was observed that even if there are some contradictions and omissions and discrepancies, the entire evidence cannot be disregarded. After exercising care and caution and sifting through the evidence to separate truth from untruth, exaggeration and improvements, the court can come to a conclusion as to whether residuary evidence is sufficient to convict the accused. Thus, undue importance should not be attached to them which do not go to the heart of the matter, and minor discrepancies are bound to occur in the statement of witnesses. In Ugarahir versus State of Bihar, the Honorable Supreme Court categorically held that the maxim falsus in uno, falsus in omnibus is not made applicable in India, and observed that hardly one comes across a witness whose evidence does not contain a grain of untruth or at any rate exaggerations, embroideries, or embellishments. It is therefore the duty of the court to scrutinize the evidence carefully and separate the grain from the chaff. From the above observations of the Honorable Supreme Court, it is clear that mere inconsistencies in the evidence of the witness with that of their former statements does not completely discredit the evidence of the witness and would affect only that part of the contradiction, unless the court is otherwise completely satisfied that the witness is completely unreliable. To conclude, a police officer under section 161 of Code of Criminal Procedure can examine the person whom he believes to be acquainted with the facts of the case and reduces the statement made by such person into writing. Such recorded statement cannot be used as substantive evidence, but can only be used by the accused or by the prosecution to contradict such witness in the manner enumerated in section 145 of the Indian Evidence Act. When the statements are so used, any part thereof may also be used in the re-examination of such witnesses, but only for explaining any matter referred to in his cross-examination. The tool of cross-examination is very vital in the hands of the accused to elicit contradictions. Once the contradiction is brought on record properly, it is the duty of the court to properly assess the contradictions and to come to a conclusion as to how much weight can be attributed to such contradictions. The same should be done bearing in mind the settled principles of law. That is to say, neither the contradiction should be thrown out at the threshold, as doing so would undermine the valuable right of the accused, as the facts set out by prosecution sometimes may not be accurate. Similarly, the contradictions should not be considered as gospel truth to impeach the credit of the witness completely, as one statement alone cannot entirely make the whole evidence of a particular witness false or unbelievable. The evidence has to be read as a whole, and the rule of benefit of doubt should not be overemphasized, which would lead to the acquittal and thereby letting the guilty escape. For the object of a criminal trial is not only protecting the innocent, but also to see that the guilty should be punished, and to achieve this, an object-based approach has to be adopted by the courts to meet the ends of justice. And with this, I conclude my topic for presentation. And I thank each one of you for patient hearing. Thank you.
Now it is time for seeking clarifications from the topic from the source person. I request all the officers to raise any doubts or to raise any questions, whatever they have pertaining to the evidentiary value of the admissibility of 161 CRPC statements, which are used for the purpose of contradiction also in the cross-examination of witnesses. Yes, Javed Pasha garu, you are raising your hand. You don't have any doubt. Oh, everybody has become so perfect except myself, because I am the person who is asking doubts.
Namaste, sir. Malik Sarma garu. I have one doubt.
Okay, very good. Please proceed. Thank you for saving me.
Yes,
Sir,
ma'am, please.
actually, for the contradictions, for the statements given to the police,
Uh-huh.
as you said, it can be, it can sometimes it can be clarified through IO.
Yes.
But as per 164 statement recorded by the magistrate,
Uh-huh.
if the counsel for defense has elicited any contradictions with regard to this 164 statement, and already the charge sheet has been filed and the police has not cited the magistrate as a witness, and it is true that as per apex court orders, for exam for 164 statement regarding magistrate cannot be examined before the court. So,
Yes.
if the counsel contradicts with the 164 statement, elicits any contradictions, is it necessary for the trial court judge to summon him, or we should conclude the 164 statement as final, and we have to appreciate it, or
Okay.
what we have to do?
Okay, ma'am. I'll try to answer this. See, I mean, as you said, madam, there is a judgment of our own High Court wherein it deprecated the practice of calling magistrates who has recorded 164 CRPC statements. But having said that, when there is, let me again go back to section 145 of Indian Evidence Act, wherein it says that in the second part, second proviso, if there is a contradiction that has been elicited, then it is not complete if we apply the law as is stated in V.K. Mishra's case. But although V.K. Mishra's case is only talking about a police office investigating officer when he is when he comes to the court to depose his evidence, but if we consider the same, if we apply the same ratio, in my opinion, the counsel for the accused may move an application for summoning of the magistrate, because he has to get the contradiction completed, and unless the contradiction is completed, that cannot be read in the evidence. So I mean, did I made myself clear, ma'am? I mean, have I answered your question?
Sir, little bit I have another doubt. Sir, coming to the statements recorded before before police, there will not be any signature of the witness making it, and also it is usually taken by vote, on vote. So coming to 164 statement, it is given before the magistrate, and the signature of the witness is also taken. Then where is the question of again summoning the magistrate? Can't we take it as a concluding statement, and can we appreciate it without summoning the magistrate?
In my opinion, no, ma'am. Although the statement recorded by the magistrate sits on a higher pedestal, but still the process of completely bringing the contradiction onto the file and leaving it for the appreciation at the time of judgment would only be there. I mean, the contradiction would be available only when the whole circle is complete. Just because, although, I mean, as I said, whatever statement magistrate records sits on a higher pedestal, but that does not completely, the mode of proof cannot be dispensed with. That is in my opinion, and any of the seniors may kindly add or correct me.
Yes, sir. At this stage, I would try to intervene and make some clarifications. The only point of difference between the statements recorded by a police and the statement recorded by a magistrate is signature. The first thing is, the police officer is not empowered to obtain the signature of the person who is acquainted with the facts of the case, whose statement he records during the course of investigation. Secondly, if the same witness is produced before a magistrate for recording the statement under 164, the magistrate has got power to administer oath to that witness and also obtain the signature of the person, and the magistrate should also put up an endorsement below the statement that the contents have been read over to the witness who admitted them to be true and correct, and thereafter the statement would be sent to the investigating officer, and on that basis he will file the charge sheet. Then when the same witness who deposes before the magistrate alleging certain overt acts against the accused comes before the witness box and totally resiles from the 164 statement and puts up a total contradictory version before the court, whether the 164 statement would partake or overcome the evidence given by the witness before the court. See, the only point which has to be taken note of by the court is what is the deposition of the witness which is made before the court during the course of trial, but not otherwise. Then what will happen to the 164 CRPC statement of that particular witness who has given before a magistrate, supporting the contents of the complaint or supporting the narration of the other witnesses under 161. The only thing which is left before the court at that stage is when 164 is being contradicted by the very same witness before the court to initiate the process of perjury. The same witness can be prosecuted for the purpose of perjury, but when the substantive piece of evidence before the court is totally contrary to the 164 statement, the court cannot ignore the evidence given by a particular witness before the court and cannot totally rely upon the 164 CRPC statement. For all purposes, it is only a previous statement, but it has got certain additional trappings of being recorded before a magistrate, administering the oath and also reading the contents to the witness who, after admitting them to be true only, the magistrate affixes his signature. So it is a sacrosanct value and it has got a what you call higher pedestal while considering the statements. But when considering the evidence which is given by the witnesses before the court, the 164 statement cannot override the evidence given by that particular witness. Then what is the evidentiary value of that 164 statement when the witness doesn't admit except the signature? So the investigating officer will be marking that 164 statement, or the public prosecutor, if so insists, we can also mark the 164 statement even though the witness doesn't admit. Then how can it be marked? When she admits her signature, there are certain cases where the signature itself is also denied. The victim says that I do not know who has obtained my signature, I never appeared before a magistrate never recorded, I never went to any other court except today. So all these things would be coming from the mouth of the witness in a parrot-like manner. So ultimately, what is the evidentiary value of that 164 statement which is marked through the investigating officer when the witness resides, when the witness doesn't admit it to be true, or when witness totally denies that she has ever given such statement? Then it is for the court to evaluate. Here the role of the court would come into picture, that evaluation of the evidence given by the particular witness before the court vis-a-vis the 164 CRPC statement, apart from the other attending the circumstances and the other evidence of the witnesses, we have to decide the matter. But this 164 statement value will be, it is nothing but mere piece of paper when the witness totally denies. Because we are not supposed to totally rely upon that 164 statement and convict the accused. The only course open to the court is that since you gave a statement before a magistrate doesn't have any other motive to falsely impute a particular statement which is not made before you, though it is made by you under oath, recorded by a judicial magistrate during the course of judicial proceeding or judicial inquiry. So therefore, why you should not be punished for perjury? You can as well initiate perjury proceedings against that witness, but simply because it is resiled, that cannot be taken note of and that cannot be relied upon, and accused cannot be convicted. This is my opinion. I solicit any other opinion also, because it is a learning process. Don't think that whatever I say or whatever you say is the gospel truth, because law evolves. Okay, please. Somebody is.
Sir, actually, the witness is not resiled, sir. Here, the 164 statement is some contradictions are elicited.
Okay.
Madam, one thing, this is answer.
What do you mean? Can you give an example? What are those contradictions which are elicited? To clarify, please clarify.
Sir, if I have to quote an example, sir, while recording the 164 statement, the victim may say that.
Radhika Garu, she was expressing a doubt. She was saying that there are some contradictions. So let us ascertain from her what type of those contradictions which she has elicited. Then you can supplement.
Thank you.
Radhika, please explain what are those contradictions, how they are different from the statement made by the witness before you. I think the connection is large. Sarma, you can proceed.
Sir, I was just trying to give an example, sir.
Yes, okay.
The case. Say in 164 statement recorded by the magistrate, if the victim says that he has taken me somewhere blindfolded, and later she says that probably he has not blindfolded me, but he has taken me to a place, and after that I was made unconscious. So probably this is a contradiction in the 164 what was stated before the magistrate and the statement that has been made before the court. So probably in this situation, then can the magistrate not be called? Because I was just looking in the chat box. Commissioner ma'am has stated has given the citation of Kashmira Singh versus State of MP, there 1952 SC 159, wherein it was held that the magistrate need not be called upon to complete the contradiction.
See, the only thing is, I'll try to add some more to that.
Sir.
Summoning a magistrate for the purpose of examining and marking the 164 statement is totally a different thing. We are only on the point of to deal with the contradiction which has been present in the testimony of the witness in our classification with reference to the 164. Magistrate comes and says whatever the witness has spoken before, nothing more there. Investigating officer is concerned, he is the person who records the statement of so many witnesses who are acquainted with the facts of the case. He affects the confession of the accused and he conducts the investigation to its logical conclusion and files the charge sheet. Role is very, very greater than the role of a magistrate, which is only twice in a narrow compass. Magistrate only records the statement under 164. His role only ends there and he has nothing to do with the other aspects pertaining to the case. Yes. So when a magistrate is summoned, what is that he will say? Whatever the witness has spoken before me, I have narrated in verbatim. Nothing more, nothing less. So I am no way concerned with other aspects. And whether she deposes before the court supporting that 164 or becomes hostile or supports half of that statement and rest of the things she doesn't support, it is not the concern of the magistrate. Secondly, it is the duty of the court to evaluate the 164 CRPC statement. How the 164 CRPC statement is corroborating the other material on record, whether it contains the ring of the truth, whether there are any improvements, embellishments which go to the root of the matter, or whether it is totally contradictory or supportive. It is for the court to decide. Summoning or not summoning the magistrate is of no consequence at all when 164 is already brought on record. So you cannot draw a parallel between a magistrate and an investigating officer. Recording of statements is one and the same in these two cases, but there lies a hell of a lot of difference. A great deal of difference lies in between. This aspect has to be appreciated while evaluating the evidence. Okay?
Right. Thank you.
Please proceed, sir. Take other questions.
Sure.
Johnson sir was saying something. Sir, Johnson sir, please proceed.
Sir, you have clarified all this, but only I want to add something. Basically, 161 statement CRPC is recorded by the police officer during the course of investigation, and the 161 statement is not a voluntary statement according to language of the section 161. 161 statement, 161 section clearly says the police officer should examine all the witnesses who are acquainted with the facts of the case. Then witness has to answer truly all the questions put by the investigation officer. And subsection clause 3 says that the such police officer may reduce the same into writing. So it is very clear, 161 statement is also not a voluntary statement of the witness. The IO has to elicit the facts and reduce the same into writing. That is the language. Coming to the 164, it is on administration of oath. the witness speak voluntarily before the court and he gives statement of the facts of the case. Both the statements are not substantive piece of evidence. They are subject to scrutiny by the court when the witness supports the case of prosecution with regard to the particular statement. If he resigns from the statement, the prosecution has to declare that witness as hostile after taking permission from the court. And declaring the witness is also, it is not mandatory in all the cases. It is always discretion of the court to permit the witness to declare as hostile when he resigns from the statement and goes against the party who called him. Then subject to cross-examination, whether 161 statement or 164 statement can be used by the accused only to contradict the witness. If he supports the witness, the question of contradiction does not arise. It can be used by the opposite party to contradict the witness. Generally, what we say, generally we come across nowadays, the witness who supports the case will say in the court that police not examining him. And the witness who comes hostile will say police examined him. Then what is the evidential value of that statements? As said to Mr. Srinivas Reddy Garu, that can be used as to contradict or to corroborate the witnesses subject to proof, and the evidence given before the court is only admissible in evidence. Why? Because the evidence recorded before the court is recorded in the presence of the accused. But 161 statement as well as 164 statement are recorded in the absence of the accused, so that they are not at all substantive piece of evidence. The evidence given in the court is only admissible subject to proof of contradictions, omissions, and so on. This is also in addition to the clarification given by Dr. Srinivas Reddy. Please.
Thank you, sir.
Yes. Any other questions from any of the officers? Sharmagar, you have referred to the FIR, the complaint or report attached to the FIR. See, when an accused comes and says before the investigating officer that he has killed his wife,
Sir.
and on the basis of that statement, the FIR is registered. Whether can that FIR can be treated as a previous statement of any other person who accompanied the accused at the time of lodging the report? Because both of them would be available at the immediate spot before the investigating officer, and he records the statements of both of them. But they do not come within the purview of 161, but they are the statements recorded while admitting the or acknowledging the guilt. So whether those statements can be confronted to the accused during the course of trial.
Sir, in my opinion, it is not a substantive piece of evidence in the first place, as Your Honor said, sir. And secondly, can that be confronted? Is confrontation to the accused would only come when the accused gets into the witness box in the first place. And if he does not choose to get into the witness box, there is no confrontation. And even otherwise, if he enters into the witness box, and if at all he enters into the witness box, yes, that becomes his former statement. But like Your Honor said, the other person who has accompanied him, he is not the one who made the report to the police, and that the second person cannot be confronted with the FIR. At the most, what can be asked of the second person is that you have accompanied him, and that is why it is stated, whether for the purpose of corroboration or contradiction, whether anything of that sort can be elicited or not can be done, sir. But it cannot, that is only to impeach the credit of witness, that is under 145(1) without confronting it. Because without confronting, even irrespective of whatever, whether there is any formal statement of a person or not, and even variation falling from the statements of different persons can also be put to the witness under the first limb of 145.
True, but to whom that FIR has to be marked, FIR along with the complaint. Because the person who gave that information to the police on which basis the FIR is registered is none other than the accused. Is it not?
Sir.
There won't be any complainant to show him as LW1. So it is a statement of the accused that is reduced into writing on which basis the criminal investigation commences, FIR is being registered. and the person who accompanied the accused, probably he may be shown as one of the witnesses or not. Or if during the investigation, if it is found that he also supported the accused, then he can be implicated under section 34.
Yes, sir. Sir,
What would be the evidentiary value of that FIR? It is not a substantive piece of evidence as we know. Then how it has to be marked? Through whom? If it is marked through the investigating officer, whether the investigating officer can be cross-examined on the basis of the contents of the complaint before, because he is the person before whom that FIR is being registered, including contents of the complaint.
Sir, I plead my ignorance on this aspect, sir. I do not have an answer to this.
Sir, Srivastava.
Yes, sir.
In my opinion, the information given by the accused to the station house officer or police officer as to commission of offence, and if it is registered in writing or otherwise recorded by the police by way of statement, only if the accused himself given report and except the inculpatory statement regarding his involvement in the offence or commission of offence can be excluded, and the rest of the things after preliminary inquiry the police, if the police satisfied that there is a prima facie case and a cognizable offence made out, the FIR can be registered, but that can be used only with regard to the exculpatory statements. But inculpatory statement cannot be used as against the accused, even again an accomplice witness also. They can be used only for the purpose of exculpatory statement regarding finding of the particular material fact or otherwise any relevant fact, except that the incriminating circumstances in the statement cannot be used against the accused, in my opinion.
But does it not amount to confession? Straight away he comes along with a knife and places it before the table of the investigating officer.
Yes, sir. Though it is a confession, that's why inculpatory statement cannot be used against the accused. If it is admitted, because there is no question of investigation, straight away filing charge sheet against the accused. If it is that other evidence has to be collected by the investigation officer to ascertain the truth that whether the confession made by him is voluntary nature or not.
No, nobody pressurized him, nobody forced him, he himself came to the police station. Because police
there is no prohibition of registration of the case, and the investigation officer has to ascertain the correctness of that fact and other relevant facts. He has to visit the place of offence, he has to collect the material evidence, he has to record the statements of other witnesses. Then in that way, he can file a report under 173 against the accused person who gave information.
So ultimately, entire course of investigation would lead to the irresistible conclusion that he is the only person Mr. Accused has committed the offence. There is no
there is no other go, and that statement of the accused can be used if the other evidence collected is in corroboration.
Okay. Then any other questions from any of the officers? Okay, it appears that nobody is willing to ask any more questions, and we can go for the legal word today. I request Pradeep Garu to give his legal word.
Good evening to Honorable ADJs, Sub-Judges and Junior Civil Judges. I am very delighted and happy to share a legal phrase with you with all humbleness. The legal word I chose to share with you is that nocitur associes. Nocitur, can I proceed, sir?
Yes.
Nocitur means to know, socies means association. The meaning of maxim is that to know from association, or a word is known by the company it keeps. The maxim conveys that the meaning of a word or phrase is to be derived from its context. It is one of the rules of language used by court to interpret legislation. The maxim can be used wherever a statutory provision contains a word or phrase that is capable of bearing more than one meaning. The Honorable Supreme Court applied the principle of nociter associis in Pradeep Agarbatti Ludhiana versus State of Punjab, AIR 1998, SC 171. In the said case, the appellant was a registered dealer in Dhoop and Agarbatti. The appellant was sought to be made liable to pay sales tax at the rate of 10 paisa in a rupee, as was leviable upon items falling under the entry number 16 of Punjab General Sales Act 1948. The entry number 16 of Punjab General Sales Act reads thus: cosmetics, perfumery and toilet goods excluding toothpaste, tooth powder, kumkum and soap. The question in the case was that whether Dhoop or Dhoopbatti fell within the description of perfumery thereunder. It was held that perfumery means such articles as used in cosmetics and toilet goods, namely sprays, etc., but does not include Dhoop and Agarbattis. So the principle is applied either to enlarge or restrict the meaning of a word within the confines of a document. Hence, when a word is ambiguous, the judges look at the rest of the document to determine the meaning. This is, with this I conclude. Thank you, sir.
Okay, thank you, sir. Now I request Ravi Garu to propose vote of thanks for today's webinar.
A very good evening to Honorable State and other Honorable District Judges, Honorable Senior Civil Judges, and my senior officers and voting officers. I consider it my great privilege to propose vote of thanks for today's webinar. And also, I express my heartfelt thanks to our senior judge, Honorable Senior Justice Chella Kolandrav Garu, and our beloved Honorable PDJ Madam, Srimati Anupama Chakravarti Garu, for creating this wonderful platform of webinars during these dark days of lockdown. As we know, law is dynamic and ever changing. This knowledge sharing platform set up by our Honorable PDJ Madam is helpful for all of us in improving our legal knowledge. In this connection, I extend my sincere vote of thanks to Honorable Principal District Judge Madam for her commitment in conducting webinars and I also extend my thanks to Honorable First ADJ Garu and Honorable other additional district judges for their interaction and timely suggestions, without which these webinars would not be so much successful. This is my great privilege to propose a vote of thanks to our today's resource person, Sri K.V.M. Subrahmanya Sarma Garu, Addl, Junior Civil Judge, Husnabad. Sir, we have chosen a most important topic, that is the every judicial officer in day-to-day, in dealing our judicial functions, which is how to record contradictions with regarding to former statements made to police and its evidentiary value. Sir, you have presented the paper in an extensive and pragmatic manner. We all are undoubtedly benefited by your valuable presentation. Thank you, sir, for your valuable presentation and discussion. I also thank Sri A. Pradeep Garu, Second Additional Judicial Magistrate of First Class Karimnagar, for giving today's legal word and explaining the same with relevant case law. I also extend my thanks to all our senior judges and my colleague officers for their patient hearing and active involvement in the webinar.
I also extend my thanks to system officer and other staff of Karimnagar unit. Thank you, sir. Thank you very much. Thank you, everyone.
Thank you, sir. So, with this, we will come to an end of today's webinar. And for the Monday's webinar, the legal word will be given by the Venkateswara Garu, and the word will be proposed by Sri Parthasarathi. Okay? So thank you, one and all.